You're listening to Autumn on the Air, the weekly podcast that brings you conversations about the impact of research commercialization and the people who make it happen. Join us for interviews with patent and licensing professionals, innovators, entrepreneurs, and tech transfer leaders on the issues and trends that matter most. Keep listening for an inside track on the people, IP policies, and politics changing our world.
Welcome to Autumn on the Air. Today we're diving into a topic that's been making waves in the European patent landscape, the Unitary Patent and Unified Patent Court in 2024. As we navigate through this transformative period in European patent law, we're thrilled to have with us two experts who have been at the forefront of these changes. Our distinguished guests for today's episode are Robert Alderson and Mariella Massaro, both partners at Berggren, a full-service European IP firm. Robert is a unique figure in the intellectual property world, bridging the gap between U.S. and European patent practices. He's one of the few attorneys qualified to practice before both the United States Patent and Trademark Office and the European Patent Office, as well as the new European Unified Patent Court. With over 2 decades of experience, including 14 years in New York and more than a decade in Europe, Robert brings a wealth of knowledge to our discussion. Robert's background includes a law degree from the United States, a doctorate of veterinary medicine, and extensive experience in patent prosecution, litigation, licensing, and IP due diligence matters. Mariella is a certified licensing professional, IM 300 IP strategist, and partner at Berggren. Mariella's experience spans a wide range of IP and commercial transactions, supporting clients throughout the entire development process, from research to market across multiple jurisdictions. Mariella has been instrumental in helping clients prepare for the Unitary Patent and the Unified Patent Court by modifying license and co-ownership agreements to address the added complexity of the new European patent system. She is currently working on the UPC litigation team at Berggren. With almost 2 decades of experience in IP litigation, Mariella has handled numerous cases involving patents, trade secrets, designs, trademarks, copyright infringement, and unfair competition. Her client portfolio includes companies from diverse sectors such as pharmaceuticals, medical diagnostics, chemicals, software, heavy machinery, and household appliances. She has also represented iconic Italian companies and industries like lighting fixtures, fashion, clothing, wine, and food. Together, Robert and Mariella bring a wealth of knowledge and practical experience to our discussion on the Unitary Patent and the Unified Patent Court, offering valuable insights for our listeners navigating this new landscape in European patent law. Welcome to the podcast, Robert and Mariella.
Thank you very much, Lisa. It's good to be here.
Hi, Lisa. Thank you.
Well, very excited to have you both here. And we have a lot that we want to talk about today, particularly as it relates to the new European patent system, which I know many of our listeners are aware of. They know it includes a new type of European patent that is with unitary effect that's known as the Unitary Patent, as well as a brand new court system, the Unified Patent Court. So I thought a good place to start out today would be to talk about the Unified Patent Court because it's been extremely, extremely busy since it came into operation June 1st of last year. So Robert and Mariella, can you share with us maybe some of the key decisions that the Unified Patent Court has handed down in the last year and a half that you think tech transfer offices should be aware of?
Sure, Lisa. I think that I like to start with a case that actually does not have any particular significant issue, but it's an exemplary case, like a picture that represents what the UPC is now. The case is Seoul Viosys and Seoul Semiconductor versus Expert Klein. And it was brought in front of the court of Düsseldorf, local division. And it's quite recent, was decided the 10th of October, 2024. And the first aspect that is significant is that is the timing. The case was filed the same day, 1 year before, the 10th of October, 2023. And so this is what the UPC is, a very fast court, 12 months to the day. Also, another aspect of what the UPC does is that both infringement and validity were discussed in the same case. So forget the bifurcation of the German courts, and including the patent amendments. So also the claims were revised, and this case sees the plaintiffs asserting a classic European patent that was validated. But the interesting aspect is that it was validated in 8 countries. So the court granted a permanent injunction that has effect in 8 European countries. So from Austria to Sweden. And finally, no bond was required. So this is kind of an exemplary case.
That's amazing. 12 months, very fast. That would never happen here in the US. Permanent injunction in 8 countries, and both infringement and validity in one court. And like you said, I'm very used to German courts where there's bifurcation. So I think that's a great exemplary case to start off with.
And after that, of course, I think that everybody have heard about the famous Harvard University and 10x Genomics versus Nanostring case, because it was the first preliminary injunction granted by the UPC more than 1 year ago, the 19th of September 2023. And this case is famous, of course, among the TTO offices because it relates to a patent owned by university, Harvard, but also because having a preliminary injunction granted was made the news. This case set the standard for the UPC to grant a preliminary injunction, and what the court require is that there is a sufficient degree of certainty with regard to the validity of the patent and the likelihood of infringement. So the court basically requires that it's more likely than not that the patent is valid, and it's more likely than not that the patent is infringed. So this criteria, the standard, was confirmed also in appeal by the Court of Appeal in this case. Unfortunately, for the patent owners, the injunction per se was lifted because the Court of Appeal thought that the patent actually, it was more likely than not that patent was not valid. So there was a different claim interpretation and construction, but it's very important that the standard is still there. So the preliminary injunction was just lifted based on a different evaluation of the validity of the patent. And also the Court of Appeal case in the Nanostring versus 10x Genomics case is very important because it sets the criteria for claims interpretation, where we see that these criteria apply both for validity and infringement. And as it's common in Europe, the patent claim, of course, are the decisive basis for determining the protective scope of a European patent. But the UPC made an effort in highlighting that also the drawings and the description should be used as an aid. And this is a discussion that is very, very important now in Europe, also in other places. So these are the first cases that I think it's important to highlight. Bob, would you want to take from here?
Thank you, Mariella. I will take over for this case, the Sanofi versus Amgen. Mariella spoke about the first preliminary injunction. Sanofi Amgen was the first successful revocation action at the UPC. And of course, Sanofi Amgen has a corresponding US case and a revocation action in Europe. And in the US case, the patent was invalidated for lack of enablement. And in contrast, at the European Patent Office, the EPO maintains the general principle that generating antibodies is for a known target is a matter of routine. So what's not enabled in the U.S. is a matter of routine, apparently, at the EPO. But at the EPO, the challenge is to show inventive step, that is non-obviousness. So the UPC followed the EPO in this regard, although it did not apply the famous problem-solution approach that the EPO uses. The EPO typically starts the problem-solution approach for non-obviousness or obviousness by identifying the closest prior art. And the UPC panel said that a reasonable starting point is sufficient and that there could be a number of such starting points. So it actually shows that the UPC is prepared to deviate somewhat from the EPO's position. We also see the UPC deviating from national law, for example, German national law. But in any event, the take-home message, for the sake of time, may be that in drafting new applications with functional antibody language, at the very beginning, I think it's important to consider if you're going to file the application in the U.S. and in Europe, consider both the scope of your claims to satisfy the enablement requirement in the U.S. and to also satisfy the inventive step and obviousness in Europe. And I think this would suggest that with this and other changes in the European system, perhaps greater collaboration and cooperation between U.S. and European patent attorneys early on would be warranted. The next case we'll discuss relates to the application of the doctrine of equivalence at the UPC. In general, in Europe, the scope of protection in cases of when analyzing doctrine of equivalence is governed by Article 69 of the EPC and its corresponding protocol. To make a long story short, what happened in this case is that the UPC actually ends up applying a doctrine of equivalence standard that looks very much like the function way result doctrine of equivalent assessment. Various commentators have even commented on how similar the UPC's decision was to the assessment of DOE in the U.S. with the function way result three-part test. So that's kind of the upshot of that case. So Mariella, I believe you're going to speak about the next case, correct?
Yes. We have so many interesting cases, and it was really difficult to select.
Very difficult.
Most interesting to comment today. But one issue that came in several cases is what happens when there is a UPC action that is conducted in parallel with the EPO opposition. And I think that the first one was Astellas versus Herios, discussed at the Munich Central Division in 2023. But many other cases followed. And the UPC has been consistent, so various local divisions and central division basically refused to stay the proceedings unless the EPO position would be decided very shortly. So we are speaking about months. In many cases, like in the Astellas versus Helios, several months, like 8 months, were separated. Basically, the oral hearing with one of the oral hearing of the EPO, and so the UPC basically decided to go ahead and as a consequence, filing an opposition at the EPO, whenever, of course, we are in the 9-month time period to do so, cannot be used as a delay tactic for staying in a UPC case.
Well, thank you both very much. I mean, I know that wasn't an easy task to come up with a list of cases because there's been so much activity, but thank you. That was a really, really great overview. And I want to talk and turn a little bit more now, focus on the unitary patent and filing and prosecution strategy. But to start things off, I thought I would just mention, the uptick of unitary patents because they're gaining more and more traction. And from what I understand, almost 1 in every 4 European patents granted by the European Patent Office has been converted into a unitary patent, which translates to about a 25% uptake rate in 2024, with over 42,000 registrations in total since June of 2023. So before we get into filing and strategy in detail, I do want to remind our listeners about something that's called the transitional period for European patent applications. Robert, can you remind us a little bit about what the transitional period is all about and what TTOs need to remember about it?
Yeah, so with this new system, I guess the idea was you didn't want to just jump from one system to another system right away. It would be too disruptive. So there will be a transition period, and I will speak about the details of that in just a second. But the transition period will last at least 7 years from 2023 up to a total of a maximum of 14 years. So that means that this transition period will last until at least 2030 and could go as long as 2037. There is some discussion that it may go past 2030, but only by a couple of years, but we'll see how that goes. So it's important to understand that the UPC, the Unified Patent Court, has jurisdiction by default over all European patents, and that this jurisdiction is shared by national courts. Now, the exception to this is if the patentee opts the patent out, a classically validated patent, out of the jurisdiction of the UPC. And that would take the jurisdiction of the UPC is then cut off, and only the national courts would have jurisdiction. And this can be done. You can opt the patent out unless a UPC action had already been filed. That is, it would pin it into the UPC system. So you can opt out, and but only. And you would only be prevented from doing that if a UPC action had already been filed. And then the opt-out can be withdrawn. You can opt back in other words. And it in the same way, and that is only that can be done unless an action has already been filed at a national court, and then it would be pinned in the national court. So let me give an example. You have a classically validated European patent. You opt the patent out, and you see infringement in multiple European countries where you've validated your patent. You could withdraw the opt-out and then file an action at an appropriate UPC local division in order to take care of the infringement in a single action rather than in separate national courts. It's also important to understand that a unitary patent that Lisa just talked about, unitary patents are always subject to the jurisdiction of the UPC and cannot be opted out. And so with that background, we wanted to mention one additional case that deals with this topic and the effect of pinning a patent in a certain jurisdiction. So Mariella, are you going to jump in and talk about that case?
Yeah, thank you, Robert. The question that at the beginning, the court, the local division of Helsinki, but more recently, the Court of Appeal, it's a case that is very recent, 12th of November 2024, had to address is a tricky question. What happens if the national case was brought and so was started before the transitional period started. So the court of first instance actually thought that even a national action that started before the UPC was able to pin the patent in the national court system. But as many actually predicted, the Court of Appeal reversed this position. And so actually the rule refers to, so the pinning effect happens only during the transitional period. So when an action is brought during the transitional period. So the case is AIM Sport versus Suponor.
So I'll just add that Mariella predicted that case would be overruled.
Many people did.
Yeah, so I'll also mention that after the transition period, the opt-out will no longer be possible. So some of these issues are only for the transitional period. And so once the opt-out is not possible, all granted European patents in UPC member states will be under the jurisdiction of the UPC. And the only way you can avoid UPC jurisdiction at that point would be by filing national patent applications in the countries you're interested in. But you have to keep in mind that some European countries, you cannot obtain a patent through the PCT system, like Belgium, France, and the Netherlands. And thus, those kind of national applications in those countries, you need to file within the priority period. So if the national patent application strategy is going to be used, it's important to understand which countries you can use the PCT route and which countries you can't.
That's a really good point, Robert, because I think sometimes people automatically assume, particularly for European countries, that you file a PCT, you can go and file a national phase application in countries like France and Belgium. So that's a good reminder that we all need to check. And so, Robert and Mariella, I wanted to ask you, how can TTOs use this transitional period to balance the risk with respect to their European patent portfolios?
Sure. There are a couple of strategies that we would like to share with your listeners. So the first strategy would be using a unitary patent, so obtaining a unitary patent with the broadest possible claims, and then filing a divisional application and classically validating that patent. And that patent will have slightly narrower claims, and then opting that patent out of the jurisdiction of the UPC. So in other words, what you end up with is two different kinds of European patents with a different claim scope, which provides you with kind of a layered protection, so that, for instance, if the unitary patent is revoked based on prior art, you could argue that the slightly narrower claims scope of the classically validated patent, that those claims are not affected by the prior art because of the different scope of the claim. So that's the first strategy.
Robert and Mariella, you might know that during the last few years in the U.S., obviousness type double patenting has been in the spotlight because of cases like In Re Select and Allergan USA versus MSN Labs. Interestingly, what many applicants don't realize is that certain EPC and UPC member states, countries such as Germany, France, Italy, the Netherlands, Austria, Denmark, Sweden, and Finland, allow what's called literal double patenting. Can you tell us a little bit about what literal double patenting is? Is it similar to our statutory double patenting here in the U.S.? And how can it be used by TTOs to increase the value of licensable patent portfolios?
So this literal double patenting is only available under specific circumstances, and that circumstance is having a unitary patent and then a national patent with the same claims. And those countries that you just mentioned actually changed their patent law to allow this, and I think almost certainly this was to promote the use of the unitary patent, so that In this, what we could call strategy number 2, you would obtain a unitary patent and then also file a corresponding national patent or several in any of the countries that Lisa mentioned. There's one specific advantage with doing this in Germany, because in Germany you can delay examination of the German patent application. So you can obtain, you can file your European patent application and the German patent application, delay examination of the German application while the unitary patent, the application that will become a unitary patent, is being examined. Once you get the claims in the unitary patent, then you can request examination in Germany and file that claim set in the German application, which will likely be allowed for the same reason the claims were allowed for the unitary patent. So that's an interesting strategy that can be used that's even a little less expensive than, or even substantially less expensive than having the 2-layered European patents.
Are you seeing that used by many applicants?
We have discussed these strategies with applicants. We've discussed both of these strategies with applicants. And in fact, we have clients in the US that in fact saw infringement in multiple countries in Europe and are employing that first strategy, a unitary patent with a divisional classically validated patent in the countries, validated in the countries where they know that there's infringement. So it is a strategy that is being considered and even utilized at this point.
Yeah, and I would assume that's probably just going to grow with time, and people, as the uptake of unitary patents becomes more popular, and eventually we'll get out of this transition period as well. So I wanted to ask the two of you, in view of the decisions by the UPC to date, what do you think TTOs need to know when it comes to licensing their patent portfolios in Europe, particularly when it comes to standing to sue before the UPC, either for the patent owner or for the licensee?
Yes, it's important to remember that with respect to unitary patents, by default, so unless the license agreement says otherwise, an exclusive licensee has the right to bring an action in front of the Unified Patent Court, provided that the patent owner is given prior notice. Thus, the patent owner's / licensor prior consent is not needed. My advice, of course, for TTO is wherever possible to kind of, and whenever possible, of course, looking at US law to try to retain this right, or at least to coordinate the activity with the licensee. Robert, a few moments ago, mentioned the effect that an action has on the patent forum for litigation. So if a licensee brings an action in front of the UPC, then the patent is locked. And of course, in this case, I refer to classic European patents. Unitary patent always will end up at the Unified Patent Court, as we said before. So having said that, of course, all the templates need to be reviewed to account for all the new choices that the European patent system provides now.
Absolutely. And I'm wondering, for university inventions, are there additional complications if the patent at issue resulted from funding subject to certain contractual obligations, let's say under the Bayh-Dole Act, for example?
Yeah, actually, in the Harvard and 10x Genomics versus Nanostring case, the obligations under the Bayh-Dole Act were used by the defendant, Nanostring, to object to Harvard's standing to sue. In summary, the defendant Nanostring objected that the U.S. funding had been conditional on non-exclusive licenses being granted to third parties. And this is in compliance with the Bayh-Dole Act. While in that case, Harvard granted 2 exclusive licenses to the 10x Genomics, 2 because they related to different territories in Europe. And as a result of such violation or presumed violation of the Bayh-Dole Act, Nanostring affirmed that the rights to the invention are passed to the US government. Unfortunately, we don't have an answer from the court in this case because this defense was raised during the preliminary injunction proceeding, and the court basically said that it was not relevant for that stage, and the court of first instance during the proceeding on the merit would address this issue. And we don't have a decision on the merit yet. So maybe next year we can chat again about this case, Lisa.
Absolutely. We're going to have the two of you back because the rate that the Unified Patent Court is going, there's going to be a lot more to talk about, I'm sure. So keeping on this theme, Mariella, I want to ask you, do you have any recommended specific language that you think should be included in license agreements regarding this whole issue of standing to sue?
Yeah, keeping into account the U.S. law provisions that require the licensor to give the licensee, the exclusive licensee, the right to sue, we may want to introduce some language in the agreement where we coordinate the right of the patentee/licensor to choose the venue, basically the right to opt out or withdraw the opt-out, with the right of the licensee to sue, because we don't want that the licensee is the one who decides the venue. I am going to the UPC or at a national court. Well, this right is recognized to the patent owner. And so this may be a compromise that can be considered. But of course, this is from a European perspective. And I leave this point to my colleagues in the United States.
Fair enough. So, Mariella, I wanted to ask you, for patent applications that are jointly owned between two universities or a university and a private entity, what aspects do you think need to be considered at the time of filing a European application?
Yes, Lisa. First of all, now we have so many options that are available. Are we going to request a unitary patent or validate? And if we validate, are we going to opt out or withdraw at a certain point and opt out in case of infringement? All these options need to be accounted for in a co-ownership agreement, because these are choices that maybe need to be done down the road, many years from when the co-ownership agreement is originally signed. And it's difficult to bring together all the relevant co-owners. Also, there is a particular aspect that is relevant. The consent of all co-owners is necessary to opt out a classically validated patent. And because the register actually doesn't check the validity of the opt-outs, we had even a case recently that where an opt-out was deemed invalid. It was a nullity and validity case brought by Toyota Motor Europe against a German company that actually is a branch of is part of a group of a US group. So in that case, the opt-out was done by the US company without mentioning the German company of the group. And unfortunately, the lack of any evidence of the consent of the German company, and or the fact that was the application for opt-out was lodged also on behalf of the German company, led to the nullity of the opt-out, and so the case is currently pending at the UPC. Also, another, if we want a practical aspect, is the fact that in front of the EPO, but also importantly in front of the UPC, is the first applicant listed in the patent application that is deemed as presumed to be the former representative. And this has an additional consequence that the law that governs the patent as an object of property, and for instance, this is relevant to determine which rights the co-owners have, like the rights to transfer its share of the patent or sub-license or license. Actually, this law is determined in connection with the first applicant that is listed in the application, and if the first or second or third applicant actually don't have any connection with the UPC member states, and so no European law actually is related to the principal place of business or place of business of the applicants, is German law that will be automatically applied. So practical issue, who is listed first, but in the event none of the parties have connection with Europe, at least the important thing that TTOs have to remember is that whatever they write in the agreement can supersede what the German or French or Italian law says in this respect. No mandatory provision is applied, and so make sure that all the issues that you deem important for you in your co-ownership agreement with respect to the rights of the co-owner are addressed specifically in the agreement. But I know that this is already done in like it is the US style to be very detailed, and so in this respect, that's it's just further encouragement to do so.
So how does representation of joint owners before the EPO and UPC work, and during the transitional period, how does opting out work?
Yes, so there is a similar mechanism. Of course, the co-owners may appoint a common representative, and this is actually what it should be done. Sometimes in also universities designate a lead institution. If no common representative is designated, in general, is the first applicant to be listed that is considered the common representative. And with respect to the UPC, so this is even more relevant because there are issues that relate to the patent as an object of property. For instance, the rights of the co-owner to grant licenses or to sell and transfer their share of the patent. These are all issues that relate to the patent as an object of property. All these issues will be governed by the law that is the law of the country where the first applicant is the first applicant. And so even if it's an agreement, a co-ownership agreement between two US entities, and so none of them has any place of business or principal place of business in a UPC member state, then in this case it will be German law. So having in mind that depending on the nationality of the co-owners, a different law can apply. Then the most practical approach is to just write everything we want in the co-ownership agreement in order not to be subject to a foreign law, to a provision that we are not comfortable with. So this is basically our point of view.
Absolutely. And there can be some pretty big contractual implications of joint ownership in Europe, correct?
Oh, yes, indeed. Under certain UPC member states law, a co-owner may transfer its share of the patent without the consent of the other co-owners, or even grant a license to use the patent in place of the co-owner itself. So that is important to remember. What is our preferred position on this point? And none of these provisions are mandatory. So whatever is written in the agreement will be enforced.
Absolutely. So Robert and Mariella, as the podcast comes to a close, I'd be curious to know what you think TTOs should watch out for in 2025 in connection with the Unitary Patent and the UPC.
Sure, I'll take this one. I think that we will see trends that we've already started to see in 2024 become even more prominent as we head into 2025. And I think one of the main things that we're going to see is the use of UPC litigation for settlement. And one reason for that is, as Mariella mentioned in the very first case, the courts act quite quickly. Also, they have a permanent injunction is available at the end of, let's say, 12 months. And the cost, when compared to, let's say, a U.S. district court litigation, is quite favorable. I think what we're going to see is the use of the UPC either alone or as part of parallel litigation to get a quick judgment and a permanent injunction that can be used as leverage to settle cases elsewhere. So I think that's going to be one of the biggest trends that we'll see, and I think that could be particularly useful for licensees of university technology. I think the second thing that we'll see, and it's in a way related to the first, is, Lisa, as you mentioned, we're already seeing unitary patents selected 25% of the time. In 2023, the second half of 2023, I think the uptake was about 17%. We're up to 25%. And I think we may be even higher next year. And part of that could be that over the past several months, with the decisions that have come out, that the stakeholders have appreciate the competence of the UPC and maybe, if anything, a slightly pro-patentee approach to things. So those would be the two biggest trends that I would be predicting for 2025 that U.S. universities should be thinking about.
Great. Well, thank you so much, Robert and Mariella, for all your time and expertise today. You two really are on the forefront of everything that's going on with respect to the Unitary Patent and the UPC. We greatly appreciate you being here. And I note to our listeners, if you want to learn more about specific topics we talked about today, please reach out to me. I'm happy to have Robert and Mariella back to talk about those topics. Or I believe, Robert and Mariella, you and your colleagues will be at the autumn annual meeting in March, correct?
We will be there at the Gaylord Hotel. Yes, we will.
Yes, we will.
Excellent. Well, thank you so much again, the two of you, for your time and all your expertise today. This has been a great discussion.
Thank you, Lisa.
Thank you.
Thanks for listening to Autumn on the Air with Lisa Mueller. Get social with us and share your thoughts. You can tweet us at AUTM or visit us online at autm.net. We'll be back next week on the air. Be sure to join us.